Hi, everyone. Good evening. Carl Steinbeck here. Just want to recap today. We had day 5. I don't want to talk about this Ian Whiffen from Cellbrite tonight. Otherwise, I may say something, just a sentence or two about it at the end. But I just want to get straight to ARCCA witnesses. And we pretty much just heard from Dr. Daniel Wolf for most of this, of the 2 ARCCA witnesses. The other ARCCA witness, Dr. Westler, he was only on the stand for a few minutes on direct. The defense didn't even cross him. I put out my title about the lawless court strikes out versus ARCCA before I've even seen more than a few minutes of this, because it's really a disgrace what Hank Brennan was trying to do to this ARCCA doctorate degreed expert in accident reconstruction. And he's the way he talked to him, the tone of voice, everything, it was an absolute shameful behavior. You would not see this kind of conduct of an attorney being condoned in any normal court of law here in America. So to have this judge sit there and let this guy just basically berate and insult and basically in a mocking tone try to talk down to this highly esteemed Dr. Wolf, which it just made my blood boil and made me seething mad. But I can tell you that has the character that obviously Hank Brennan hasn't had so far in his life. It really makes me wonder what the heck happened to this kid him as a kid. Was he locked in the basement, chained up for 10 years or something? I mean, why does he have such unbecoming, unprofessional, and I could go on and on. I mean, I gotta try to be professional here myself. But anyway, so I just want to jump right into it, and I'll do commentaries that's going along, and I guess it works better if I stop it momentarily to make a comment. But it's I think there's a really good comment here. Keep in mind, this hearing, this voir dire hearing, was called because the judge ordered it. She on her own decided, like, we're gonna call him here. We're gonna get him here, and we're gonna get him here next week. And as it turns out, that even cutthroat Hank Brennan didn't even ask for that. And then the defense is like, well, can't they even do it through Zoom? And she's like, no, she wanted him here. So this was punishment for ARCCA. This is nothing but pure, unmitigated punishment. Extract some punishment out of them, because they're the best thing to keep Karen Reed out of prison, out of this conviction that they're so desperately seeking against her. So like I say, they can only win this case if they hide the truth. So they're not stopping anything. And for Hank Brennan to act this way towards a professional, somebody with a PhD, and it's just unbelievable that the judge would allow this to happen. Unbelievable you could find somebody that much of a fool to do it, number one. Then you have that much of a judge that just sits there and allows this to happen and doesn't even reel him in. But keep in mind, she's the one that wanted this to happen. She knows how much damage the ARCCA experts can do to the state's case. And that's why she wanted to help Brennan any way she can to come up with some kind of dirt on these guys and dirt on the attorneys for the defense. So looking for this one comment here. Here, Mandy, this is exactly what I'm thinking, and I've been saying this whole thing was a setup from the get-go by the judge, because she thought we're gonna trip these guys up. I'm gonna get Alan Jackson booted one way or the other. I'm gonna get these ARCCA witnesses booted for discovery violations because they acted in concert with Alan Jackson. So Mandy's saying this quote unquote voir dire due to trumped up alleged discovery violations was clearly pretext to interrogate ARCCA for nefarious reasons. So they thought they were going to be able to do a 2-for-1 kill. They're going to be able to knock out, or 3-for-1, I guess, with 2 ARCCA witnesses. They can take care of these 2 ARCCA witnesses and have something to come back at Jackson and maybe do some unethical violation and sanctions at the end of this case. So as it turns out, from what I've seen in bits and pieces, the rest of it since I posted this announcement, it was really a strikeout for both the judge and the prosecution. So let's go ahead and I'm going to see if there's any comments here in the beginning before I jump in. Yeah, some comment. The judge's conduct again, so one-sided. Just Brennan just running off at the mouth, just dragging stuff out with insults and jabs, and she just sat there and let that happen. It absolute disgusting behavior for both of them. It's a sham court. Nothing respectable or honorable about it. All right, so here we go.
Thank you.
We're back in session. You may be seated.
Super long breaks,
For the
never
record,
starts
legal
on
report is
time.
Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you. All right, so
Jury's
we
not
know
present.
that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCCA witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies.
Okay, let me stop right there. First of all, she said she made a ruling that they violated reciprocal discovery. And are you aware of the fact that she never made any findings? She just declared that they violated it. She never made any findings. A real judge is supposed to make findings such as saying the date, time, specifics, what the facts are that she found to be credible to arrive at a decision. She just made a decision without having any findings to back it up. And then what we heard from this ARCCA testimony today, that it basically exonerated the defense team because they didn't have conversations with the defense. They didn't discuss their testimony. They weren't hired by the defense. So I think it totally exonerates the defense.
To be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure.
Yeah, and just keep in mind, the reciprocal discovery is never complied with by the prosecution. They can come up with an expert just a couple months before trial and expect the defense team, who haven't even had the opportunity to legally hire and retain ARCCA, to prevent them from being able to have ARCCA test this even more. So the burden, the blame, I should say, is really on the Commonwealth, because they've had this case for over 3 years, and they want to come up with their own expert now, just late in the game. The reason they're doing that is because they knew these ARCCA witnesses blew their so-called expert, Trooper Paul, out of the water. So this whole thing is nothing but smoke and mirrors. It's a way to try to deny the defense their due process in this court. So once again, you don't have a judge that makes rulings based on findings. There's no findings she made. She just made a declaration. If she had to make findings and write them out of what led to her to make the conclusion that there was discovery violations, then that would be one thing. But she couldn't even do that. And then all she had was Brennan complaining and complaining, saying, basically he thinks that they're hiding something. So his mere "I think they're hiding something" made her believe she needed to help them set a trap for ARCCA and the defense team by making them show up here. Not even a Zoom call would work. It's just an absolute demonstration of complete bias and prejudice against everything on the defense.
Procedure And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So
Yeah,
today we're going to have an
travesty.
evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them.
Yeah, she didn't care one iota for speeding this thing up. You'll see that here
So,
as we
Mr.
get to it.
Brennan, who are we going with first? Dr. Wolf?
Please.
Okay.
Does that guy look trustworthy to y'all? He is mean. He's meaner than you can ever imagine a prosecutor could be. He's paid to get a conviction, so things are kind of process, not necessary.
You solemnly swear that the testimony you shall give to the court and the matter
Keep
for
out
hearing shall be the truth,
pro-defense
nothing but the truth,
evidence.
Nothing but the truth, so help you God.
Yes.
Thank you.
Is Dr. Wolf.
All right, go right ahead, Mr.
Thank you.
Brennan.
Good afternoon, doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes,
Did you receive a copy of that order?
yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolf to identify himself.
Please identify yourself.
He
for the
forgot to
record,
even
spell your last
identify
name.
him.
Daniel Wolf, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes,
Did you understand that there was a request for certain communications?
yes,
Did you understand that you were supposed to turn those records over to the Superior Court?
yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to
This-
the Superior Court, did you?
This is such a garbage comment here from him saying that he didn't send it directly to the judge. Nobody sends this directly to the judge. The judge knows that. Hank Brennan knows that. This is nothing but mere harassment of this witness.
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Miss Little last year, I was under T-Mobile was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. And then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time, who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated.
What's this fishing expedition matter? Why does it matter who all he had an email contact with, who he phoned? The substance of what he's testifying to as an expert is not an issue. He's had this opinion before the defense even knew about him and vice versa. What Hank Brennan is worried about is his expert opinion along with his other partner, Dr. Rentschler. It just completely shows what a farce their whole case is. So this is why he's doing everything he can to be basically a bully of this witness, to intimidate him, to harass him, and to mock him, and to get him to lose his cool and maybe not even want to cooperate. So he's just taking out his anger and unleashing it on this guy.
By phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial. Yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case. Yes.
Did you speak to Miss Little by phone?
I don't believe so. No.
Did you speak to anybody?
Hold on 1 second, please.
Look at how snarky he's coming across. Just his tone of voice is so grating. I'm telling you, I can't imagine a jury wanting to listen to this guy. No juror, I think, would like to see Hank Brennan be questioning witnesses and arguing a case. So that's a leg up for the defense. I mean, just having him as the prosecutor. But keep in mind, he's making all these efforts to keep out constitutionally required evidence that the defense should have. So it's the only way he can win.
Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so. No.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
Did you ever have
would
any
an expert talk
conversations
for
that
Karen?
weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so. No.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that.
Keep in mind, they sent the jury home and interrupted the trial proceedings to have this ridiculous voir dire of what? What was the purpose of voir dire? There's no legitimate basis.
I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
Nowhere else has this guy ever testified to such stupid questioning, such foolishness, waste of court's time. No judge would sit there and want this kind of testimony, be holding up a jury from listening to the actual evidence that should be presented in a court of law to decide whether somebody's guilty or not of a crime. So this is what we have, is this dog and pony show.
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer?
You already said you
Or are
talked about-
still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal.
Alessia objected, but he's already answered the question. It has to do with logistics. Who cares about logistics? How is this even relevant to whether they should testify or not?
I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place. Yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about?
So he's trying to get into all this stuff about how they were hired and the money and all that kind of stuff because he's trying to make it sound like, and he wants to be able to use that in front of the jury in the event he's unsuccessful in getting them kicked off from being witnesses for the defense, to basically say was hired by the defense and basically fabricated this kind of stuff because they like Karen Reed and they like the defense team. So it's just personal bias in favor of the Karen Reed team, when all of his reporting, all of his testing was done well before he even knew about even who the case named parties were. So it's just really none of this has anything to do with anything other than they're trying to harass him. And I believe they're trying to harass him into not cooperating so that they don't even have to have an issue of them not being denied as a witness for the defense.
Fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Of course you will.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
But he'd already done the research and reporting on it. So it's not like they needed to talk about what the normal fees would have been to do this kind of testing and research. Remember, they tested about 13 areas for this case for the FBI. So that's already been done. The federal government paid for that, probably paid, what was it, $500,000 for this report. So the report's already done. It's already signed, sealed, delivered. And they pretty much just showed up to court for trial one and didn't really have much contact at all with the defense, period.
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
Yeah.
I'm not asking what you
Punishment.
determine later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking.
Who
you.
cares?
On March 20th, 2022, not the 22nd, not the 24th. March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Boom.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
Are you sure?
You're sure about that? This kind of stuff, I'm telling you, a judge would go livid. A real judge, not some phony judge like this one that was through political ties put on it, was able to be dressed as a judge. This is not a real judge in this courtroom allowing this kind of abusive treatment, harassment, badgering this witness. I mean, this is like something a schoolyard bully does. And this guy has to take it. I mean, I can tell you right now, he'd love to stand up and bust him in the mouth. To be being talked to that way, unbelievable. And he's been working hard to meet the deadlines to get this thing done because he knows this judge is out to gun him and his partner down.
Because after that 424 call, letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day, after telling them that you had permission, they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring to?
What difference does it make? You got the report.
You called Attorney Jackson and said you had the green light from the U.S. Attorney's Office. Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Who cares?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry. Are we talking about now at the end
It's
of April?
harassment.
Yeah, we're still talking at April. April.
There's nothing but
24th,
harassment. What did you
2024.
talk about in the first?
As I just discussed with you, from what I recall, it was relaying to him the clarification.
Hank's like, what did you talk about in the first minute? What did you talk about in the second minute? What did you talk about? You know, just on and on. This is not relevant. It's wasting the court's time. But this judge wants this to happen, this bully harassment. She wants it to happen. She called for it. And Hank Brennan is more than obliged to do this.
That I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year.
All right, this flippant attitude, you're just making that up. This is like, wow. I've never seen this before, guys. I've never seen something like this before. It's that bad. Unreal.
Year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those 2 phone calls?
Really?
So let's get an answer.
He's just going over
I
and
don't remember
over.
those phone calls specifically. No, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made.
No, sir.
You had never discussed any of your testing in this case during that 40-minute.
He just said it.
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never ever talked about this case.
I'm going to allow it.
Of
Correct.
course you will.
You billed for that time, didn't you?
She
I
worked
believe
for
that I kept track
Morrisby.
of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So
Trumped
yes,
up
that time
outrage.
was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it,
Yeah.
wouldn't you?
Going to allow it. Is that true?
Yes, I keep track of my time so that
Bars.
my boss knows what I'm doing. Yes.
Okay.
Who asked me that? Come on over.
This is so much a disgrace to see this kind of thing going on, to see this guy just doing his job. He's got a PhD in electrical engineering and computer engineering, and to be treated this way by someone that works for the state. Granted, he's normally a defense attorney, but you're hired as a prosecutor to represent the state. And the state is supposed to treat people with dignity and respect, especially in front of a judge. and you're going to sit there and try to beat this guy over the head with a bully club and act like he's some kind of a slime ball felon that you're trying to put away for life for killing somebody. It's the one good thing I can say is that he's not going to get away with this in front of a jury. Jury can see right through this. A guy that has this kind of persona in front of a jury, juries are turned off by this guy. All right, I'm going to try to speed this up here through the break. Sidebar.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Now, when you billed,
No.
did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families.
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
What a
Sir,
he's
I think
acting
the
like a
majority of
complete
that phone call
jerk.
was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me, letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
You mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that
Friends?
we were friends.
I didn't ask if you're friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So,
Ye-
do you remember the next time you spoke to Alan?
You know, it's not one time is this prosecutor, so-called prosecutor, referring to him as doctor, other than the first time he got up on the witness stand. He called him doctor then. He's not addressed him as doctor and never said his last name one single time. That's what a clown we got here prosecuting this case. You ought to be disgraced and be removed. Morrissey, the judge, Brennan, all these guys have no business representing the interests of justice. None whatsoever.
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you
Sorry.
have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have?
He doesn't realize that there's people like Hank Brennan in the world.
Some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided.
Hey, Mr. Harath. No, my commentary is based on the Constitution, rule of law, due process. You obviously are some kind of troll, so guess what? You're forever zapped.
The spreadsheet, which was pulled from the records, I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Oh my God.
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep this, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete text?
He just said he did.
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
Well, you didn't tell me, but you just did now. Thank you.
So next question, no
Okay.
comments, Mr. Moore.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you do?
This is because there's corruption there, Kathleen. You're asking, please help us lay persons. I think you're trying to say, understand why she allows a snarky, underhanded remarks. It's astounding. I've testified an expert as a psychologist. I've never seen like this. Well, this is what you get when you have corruption coming straight at you. They just can get away with anything. And you got people that have seriously character issues, and it's not about justice. They're hired to get a conviction because there's stuff that they need to cover up and they don't want the truth coming out. So that's what it comes down to. Karen Reed is the cannon fodder they need to protect other people with better connections than she has.
Delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
Significant.
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial. Sir.
Where were you when you were deleting this text? Were you at your office, at home?
Oh my gosh.
Remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
Oh God.
I have no idea, sir.
This is so slimy.
You can't remember deleting over 100 texts where you were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those. I don't recall that.
You said it was after the trial.
Yes.
This is bottom of the
And
barrel
out of the
scum type tactics
who were
used
you
in
texting
court.
on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
Very high pitch.
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Oh my gosh, that's
Sure.
various.
You know the benefit of Signal, don't you?
I
Bad
mean, it's
motive.
a messaging platform. Yes.
Well, encrypted app, isn't it?
What was
I-
that?
Encrypted,
I don't know, sir.
it keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard?
It's safer to use Signal than any other of these chat forums, message forums. That's why he would have said it. Brennan knows this.
In your industry?
I think we're wasting time. They're saying Karen is guilty, and that we're having time in court here talking about why a Signal chat would have been used and why Signal chat servers were used instead of some other type. Really?
To use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it
If-
your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple of phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know.
Oh my!
How many
gosh.
times did you use Signal with the
Can you
defense
believe
to
this
talk
guy?
about this case?
Going to allow it.
From what I recall, it was probably a handful of times.
When you say
Wow.
if what you
Oh,
recall,
no.
are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means. I don't know
Probably
what that
around,
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best
How-
estimate I can give you.
How long were the
expert emails
conversations
judge
on
directly.
Signal? The 4 to 5 times.
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you
That's a hazing.
times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Acting like a
You answer that. How confident are you, Dr. Wolf?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to your honor, you knew that one of the important things you need to respond to were communications between you and the defense for her honor to consider, right?
Yes,
And Signal is a communication, isn't it?
certainly.
You looked at all your
Signal.
records and you knew it listed the text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I
That's-
have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that
You mean to tell me all those 18 jurors aren't going to see this disgraceful attorney treating this witness like this? I believe that, especially when they have breaks, people are going to be surfing YouTube, searching the internet, social media. They're really going to see Brennan for what he's really like when he's not in their presence. So that's one good thing by him acting this way as a takeaway.
there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. There's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there
trial.
wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire in the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of.
Of course they want to get paid. No, they're just going to do this for free. Of course they would like to get paid.
Your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
He's a salaried employee. And if he has to do timesheets to bill to the customer, I assume it was probably a flat fee with the feds. So, and if he wants to testify elsewhere outside the parameters of the Fed, then obviously they'd like to get paid, but he's not the one that's negotiating that.
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without the qualification, the simple question is you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day. Yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she
What's
escorted
this
me here to the
relevant
courtroom.
to-
Escorted you
How is
from
the
where?
judge allowing
I
you?
think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Did you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
So now he's getting grilled about why he'd park in a church parking lot to get to the courthouse easier. That's what this is boiled down to. You got a murder case to try, Hank Brennan, and you're trying to have this guy be wire brushed on the stand because of where he parks, of all things. Are you serious? Where he parks matters? You got to be kidding.
And did you have any significance about?
I cannot believe this judge, so-called judge, allows this to happen. And you got this kind of a guy that's paid to persecute somebody and just trample all over the Constitution. It's an absolute disgrace. I can't even come up with the right words to describe how disgusting and sick this is.
The church parking lot, did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it? Pretty remarkable event, this trial, wasn't it?
What's this got to do with anything?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Oh my gosh, you must have had some kind of drug deal in the church parking lot where you must have slipped them some kind of note on some kind of questions to ask that are not in the report to do some kind of ambush against the prosecution. I mean, what are you driving at here? It's just unbelievable.
Yes.
Okay. You shook his hand. This is meeting face to face, right?
Yes.
Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so,
Yeah, out
do
in
you
public
think you had a
walking.
conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that
What is it?
ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I could certainly go into the day before.
That's what we have here. He suspects they're hiding something. There's something really secretive, some smoking gun. He's already got the smoking gun. He already talked about it in the first trial. So this is nothing but a complete waste of time. And they all know it. They all know they're just harassing these folks, but they enjoy it. That's what's so sick about these people. They don't just like to win. They like to make people suffer, make people, even innocent people suffer, even people like him, a great outstanding citizen in America, just trying to do his job. And what does he do? He comes up to Massachusetts there and gets treated like scum.
My trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia
We're gonna
airport.
get there, but we're gonna
Okay.
get there. But there's a lot more
Okay.
communications before we get even.
Oh,
close to that.
really? Wow. You're
Okay.
just really
You remember
getting a
on
lot of
June 10th
exposure now, aren't you, on
having
various acts?
conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June,
The judge wants to find a technicality to say that defense lied and this ARCCA team was a part of the lie. That's what she's going for. She's also trying to help him out with discovery to find some kind of gotcha moments. And it's all nothing but a smoke and mirrors harassment scam.
June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
Do you realize this will follow this judge the rest of her life? These YouTube videos of the court proceedings and all the comments that from all the different channels that cover this will follow her the rest of her life. The same thing with this so-called prosecutor. It's going to follow him around. People are going to look at YouTube videos for the rest of his life and see what kind of a sham and effort to deny a fair trial for Karen Reed. And so that's the one good thing for the world to see how corrupt this process is there. It's the only redeeming point about the whole thing.
So you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
Can you imagine if Alessi tried doing this or Jackson tried doing this? Just ask and answer, move on, get to the point. That's the kind of stuff she says when the defense tries asking questions. So it's just so unfair.
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
Oh my gosh. Yeah, he has a photographic memory. Every single call, exactly how long the call was, exactly every little sentence that was said in the entire call. I mean, come on, I just think that it's almost like Hank Brennan never saw the first trial and saw how credible these two experts were in that trial. It's like he's thinking that they're going to be caught and tripped up and made to look like fools. No, only Hank Brennan's looking like the fool.
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Unreal. Unreal. They could have had witness testimony today in front of the jury. Instead, this kangaroo court wants to have this kind of trash.
Showing you
Questioning.
an email. Do you recognize that?
Yes,
From you to who?
to Mr. Jackson.
Okay. And what's it labeled as?
Wolf Direct.
And that's before you testified on trials 24.
It's at 6 p.m. the night before I testified. Yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24th, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers that he asked you when you testified.
The jury's not here. This is questioning, ambush questioning. They're trying to cross-examine ARCCA witnesses to try to find a technicality that they can say they violated some kind of discovery rule or order so that they can be precluded from testifying. So it's all a rigged process.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
And that's something the prosecution experts do as well. They tell them, here's the kind of questions you need to ask me. Here's the kind of things, because they're the experts. They know what kind of things that may be harder to understand for juries. They're used to testifying in front of juries, many of them. And they're going to say, here's what you need to understand. And he knows this. It's like he's just doing this all for theatrics, just to harass the witness.
There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1. 1.
So you assisted the
Hold on.
defense before your testimony.
Hold on.
And you wonder why lawyers have a bad reputation.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his...
Most helpful to explain their expert opinion is what they do, and they all do it. And the judge knows this, and she should be cutting him off. This hearing should not even be happening.
His direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question is,
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful? Do you want to answer my question, or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Abstain.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I
The judge knows that. You know that darn right. This is what normal experts do. They pose questions to help explain their expert opinions that may not otherwise be understood by a layperson. The attorneys don't know what questions to ask. There's something outside the report that helps explain the report. This judge knows exactly what she's doing. She's condoning this. She wanted this hearing, and
just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you've said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay.
What a sleazy tactic, and you're doing it in front of a judge, and the judge is allowing this. This is so bad, folks, really bad. You know, this is the worst courtroom in America that I've ever seen. All right, the worst. It's not even a court of law. All right, it's a lawless sham tribunal.
You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that.
Just so y'all know, I mean, this is what attorneys are used to doing. This happens all the time. Any attorneys on here that are trial attorneys, they can tell you this is what you do with experts. It's this professional knowledge that the expert you use helps you convey their knowledge and their testing and whatnot to the jury. So of course they help you formulate the best questions, because you're not the expert in that area. That's why you're calling them as an expert. So they just don't want experts for Karen Reed. That's what it comes down to. They don't want the law enforcement officer, FBI retired agent Easter, to counteract the cops' testimony. So think about it. They don't allow cops to testify against cops. And here they don't want they want to have folks like Trooper Paul and this other Welcher guy that they hired last year. They want that, but they don't want defense to have the same equal chance, because they know they have a losing game.
To him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is, when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so. No, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question.
Just, you know what? They came up with their report before the defense had even talked to them. So you know that. So you're just absolutely wasting time in the court. You're actually just trying to harass and harangue this guy, okay? So justice will happen here. The jury's going to do justice. You're going to get exposed even before it goes to a jury. I believe that all this is going to unravel. All the dirty, shady tricks they've been pulling behind the scenes, it's all going to come unraveling. And this judge, as much as she can try to do to bury it, it's all going to come out and crush them on their heads.
That's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir.
He already said it over and over and over again. How many times we got to listen to this, Canoni?
I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
Just let him do this in front of a jury. Just let him do this in front of a jury. As much as this is going to just be like infuriating and getting your blood boiling, just let him be a complete jerk in front of this jury, folks. We got to let him be a complete jerk. As much as it's painful to watch, we got to let him be himself in front of this jury.
Defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor.
Wow.
The argumentation.
Did you write that?
Yes,
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis.
How many times has he got to say this? It's just nothing but sheer unmitigated harassment, unprofessional behavior, unethical behavior, absolute. Nothing like this I've ever seen in an American court of law. This is not a court of law. It's a lawless sham tribunal.
I
That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary.
Down.
Need
Shut
to
your
show the
mouth,
jury it
Brandon.
doesn't matter in this case. That's what you wrote.
Right. Need to show the jury.
Yeah.
That's what I was trying to make sure that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it?
Collaboration?
You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
Oh, shut your mouth. Will you? You're so disgusting.
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that
How does this Dr. Wolf maintain his composure against some punk like that is able to act as a prosecutor? An absolute punk. Nothing but a punk. A punk with the ability to try to put somebody behind bars for trumping up charges and trumping up evidence and hiding the ball from the jury. That's all this is. With a judge sitting there just cheering them on.
because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then
Wow.
do you defer to the defense, not the jury, trying to give the full
incriminating.
story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Let me explain.
No, I'm asking
So
you, did you
Answer
defer?
answer the
Shut your
question
mouth. I'm sorry.
first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't.
I'm sorry if I come across too loud. I'm sorry. I do have an issue when folks just absolutely trample on professionalism and due process of law. I've been living and breathing this in the military. I helped work with foreign armies, and we would teach them and train them in how to have a court of law, a rule of law system where there's foundations and bedrock principles of which you pursue justice in the military, in their own military type court-martial system. Anything from the Russians to the Germans to different countries in Africa, India, Australia, all these kind of countries. I've met with their folks, and they're trying to learn how we do it the best way. And then I see this kind of trash going on in a court of law in America, and it's so embarrassing. So I'm sorry if I'm getting too angry here for any of y'all, but it's it really burns me up.
Defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan.
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to
Normal,
explain.
normal.
Because for one,
He shouldn't have
I want
to,
the jury
but
to have an understanding, again, the
Shame on
jury
you.
to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
normal question.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to,
Did you inform the court about your misrepresentation?
What?
no, I did not
No,
inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Oh, finally, finally. How about just ending this? Yeah, make him be scrutinized.
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one,
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted,
Out of
correct?
control.
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls incoming and outgoing as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning, when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day.
You know, yeah, he's talking about revenge here. I believe that this Hank Brennan is so full of rage and hate because of what happened to him in his formative years that guys like him, I'm telling you, they are so nasty to deal with because they'll do anything and everything they can to try to mess with you. You can't have any professional interactions with them as lawyers because they'll just look for ways to try to mess you over. So I've seen people like him before, and a lot of times they wind up in positions of power where they can get away with abusing people, abusing processes, and they take utter joy and glee in doing that to make other people suffer. It's a form. It's like people that get joy torturing others. That's what it's almost like.
Right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed At trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email,
You're the worst, Brennan. You're the absolute
was the
worst.
statement under oath, you and I have never discussed the substance of your testimony.
You'd get kicked
That's
out of
so
any other
truthful.
courtroom in
We
America.
never discussed it, sir. Again, I sent it to him on my own behalf. There was
And-
no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
ARCCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls,
Verified.
I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist. So it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an.
Can you believe what he'd be like cross-examining Karen Reed? He would just go rabid on her, just a complete maniac, shouting down, yelling at her. And this judge would allow it all. So this is a good prelude for that.
Accident reconstructionist, yes.
Well, so you only talked about background, and from that, the decision was made not to call him? Or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me? The report is a general report that has yours, Dr. Rentschler, and Dr.
What's
Klein's
this got
name
to do
on
with
it. Do you agree with
anything?
me?
What's this got to do
All
with
three of our names are on it,
anything?
yes.
It doesn't distinguish who did what in that
Just
report.
harassing questions.
Correct, but I think it certainly was
entity.
testified to at the voir dire and
No
in the
mission
time
or
of trial.
goal
Before the voir dire.
other than harassment.
When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Yeah,
Well,
jury's
It
watching
would
you,
be easy
Hank.
to understand if
I
you could just tell us
guarantee
what
ya.
the conversation was. That's what I'm asking you about. You-
Objection, Your Honor.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, again, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers?
Think of it this way. This judge was, for most of her lawyer career, a public defender. I guarantee as a public defender, she never saw this in a court of law, never saw this kind of harassment, beat down, this basically a unprofessional thug beatdown of a high-class expert. Unbelievable. There's something corrupt, absolutely corrupt about this whole system up there.
That could or should be asked.
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the
What
reconstruction?
difference does it make?
No, sir.
It's just a
Did
gotcha
you,
moment.
after the
That's all it's
trial,
for.
spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
Okay. And sir, is there any other communications that you've had with the defense that you didn't tell us
It's
about
evil.
outside the texts and the phone calls and the signal calls, or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Mr. Lessie, do you have anything?
You do, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, you know how much time Mr. Brennan's.
I'm
hope so.
just
I hope
asking
so.
you.
Let's keep it professional. I don't want any name
May I
calling
approach the witness?
Yes.
over the top. Let's keep it clean.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the,
All right, so I'm going to go a little bit into Alessi's questioning, and then I'll jump ahead to I believe there's a redirect from Brennan as well before they get to the other doctor.
at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing record.
We can mark it.
Yeah, that's exactly. Thank you.
Exhibit 2.
Thank you.
Yeah, that's
I
true.
offered it into evidence, Your Honor.
Okay.
Yeah,
May I allow the witness to have that?
Yes.
please? Thank you. Take that.
All right, I'm going to speed this up here.
Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCCA had in our possession, we produced.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in
Jump ahead.
ARCCA?
Let me just clarify something real quick. So the original case,
Leslie's so well spoken and professional and likable in front of a jury. All the defense attorneys have a likability factor that you want to see in trial attorneys. Brennan, it doesn't get any worse than that. I seriously mean that.
To testify in this, and with regard
Let me
to,
jump ahead here.
and it really didn't provide a complete picture.
and in terms of report,
Months, not weeks.
what did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So
rather than listen to all this, he does talk about how he jumped through hoops. He got the information late because he wasn't cleared by the FBI, U.S. Attorney's Office to go ahead and be retained by the Karen Reed defense team. And so he's been scrambling, trying to get other testing done. And he's got the actual test done. He's just got to do the report. And he's saying he can get it done by the 7th of May. And so anyway, it's all on because of the fact that this guy here sandbagged this whole thing with their expert, and he's going to rebut the government's expert. Well, the government's expert didn't come up with stuff till sometime in January, I believe it was, so of this year. And so he needs time to see what the Wechsler expert for the prosecution is going to say and test out his own theories. So this is nothing but smoke and mirrors because Brennan knows ARCCA will blow his expert out of the water. Sorry, this got...
In your mind, nefarious or underhanded about using Signal?
no,
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
correct. Yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
I described, I know that at that point, and like I said, it was primarily confined case.
Okay.
The work,
But
maybe a report or something of that nature at that point in time.
was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you?
This is a great voice for Alessi. He's really strongly passionate about what he's questioning this expert on, and he's going to be great in front of this jury when he whatever witness he has, whether he's doing direct or cross. He's going to be great for them.
In your ability to respond to that and to determine what was done and what ARCCA might want to do in response?
Well, certainly not the report. The report was very.
Here, let me get to Brennan. Here we go. We're getting towards the end here.
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
All right. So
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that.
End of
separately.
March.
I'm talking specifically about
Last
how long
month.
it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
I'm just going to jump to the next witness. He just gets badgered for more minutes, and it's just more of this joke of a court.
Shall give to the court, and the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. so
Here's
help
the
you God.
other ARCCA expert.
All right, Dr. Rentschler, this is going to be very quick. Go ahead, Mr. Brennan. We
Thank
just
you.
need his name.
Good afternoon, doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case
I have, yes, sir.
in a last voir dire in a past trial.
That's correct.
Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I
Here we go,
believe
Ken.
there was maybe one text message.
How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Oh my gosh, what a huge discrepancy. There's something evil going on here.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I
Keeping a
repeat?
record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
don't believe that ARCCA has any specific policy for that, no, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you
cares?
have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
Well, that certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they would
Sure.
call to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by
Fair.
calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order? That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to
They
me. in a
conspired.
So you spent some time with them?
Certainly, yes.
Okay. And sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you want to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
So then you
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary,
Right.
correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do
And
that.
it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it. Yeah.
All right. I appreciate that. Thank you very much.
Yeah,
You're
we've
all
got a
set, sir.
trial going
Thank
on
you.
for more than
All
a
right.
month and a half,
Can
so
we
you
see
better get it
Counselor
done by
Sutton for
next
1 minute?
week. Okay, that was all we had for today then at the end. Someone made the comment about how Brennan was asking Dr. Wolf about the FBI and how the feds were wanting to monitor what they were doing. So I do recall that, and that was a good thing to add. I'm trying to find the place that was here. I'm gonna just take a wild guess at it here.
The same exact outline, whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question? Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
Hold on, I think we already covered that. I need to go closer to the end.
Presentation of the work you had performed in a
At trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Okay, I'm gonna
Brennan.
listen. Somebody can tell me
So,
the time on
remember
this
the next
video
time you
for
spoke to Alan?
be. I don't want to.
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping
So essentially, he mentions that he was keeping in contact with the FBI during this first trial. So I think that would have rattled Brennan. I think that's one of the things they also wanted to know. How much does the FBI know about what's going on up here? So in any event, with that, I'm going to go ahead and turn it over for questioning. I will just say this thing about this Ian Whiffen, the Cellbrite guy. I think that from what I've seen, he says some really outlandish stuff. I don't trust his credentials. They didn't describe his credentials. He makes it sound like he's an expert on everything about a phone. He can go into all these details. He can tell you everything that's going on with a phone, and yet, and also Apple Health. So anyway, it's just he contradicts himself. He says a lot of things like "I assume so," "I believe so," and experts don't really talk like that. If they're really an expert in something, they have concrete, solid conclusions, and it looks like everything he was skewing to help the prosecution here. So I think it's going to come out with the defense experts. Everything this guy's saying is not accurate, and he actually does confirm some things also that are helpful to defense, like this issue about the cell phone of John O'Keefe still being operated and being shut off around, what was that, 12:32, and Jen was already back at John O'Keefe's place at 12:36. So definitely some a lot of technical stuff that came out with him, and I think a lot of it is going to be exposed by the defense for what it is. He also says the 227 mark was, not correct. And if you look at what he's actually saying on the Google, on these type of Google searches or web browsers, he's essentially saying all you got to do is do a new search and it X's out everything old that you did. That was the gist of what he's saying, and that's just not sounding accurate from my understanding of things. So anyway, I'll go ahead and do some questions. It's already almost 2 hours in, so I'll start answering some questions. If you guys have questions, a red question mark are the easiest way for me to spot it. Oh, thanks, Kiwi Green. Let's see here. Nancy 27, you're asking, can the state or government do something to reprimand Brendan and Judge after this hearing? I mean, they were already involved in the first trial. Well, the problem is that whole state is that way. The whole state, you can't get any kind of justice up there because they're all in on it. Rule Thomas, you're saying Whiffen is claiming that John just stayed near the flagpole but walked 84 feet. Under that theory, John just walked around the post waiting to be hit by the Lexus. Yeah, and he's also saying he was, as I recall, he said he was in this range of a red circle, but yet he says he believes he was by the flagpole during all that time, or something along those lines. And it's just not credible how he's constantly always trying to take something, making a broad assertion, and he's not confident of, and then he makes a confident determination, or at least an assumption that John was there by the flagpole for a long time. Coffee Cake, what's your biggest concern for the defense? My biggest concern is they were not going to be aggressive enough. And after seeing what happened in the first trial and what's happened up until today, even, they need to be aggressive. And I think they got that aggressive tone that they need to have. And because if they're not aggressive and they let this judge run roughshod over them, then it's going to be a lot harder to get justice for Karen Reed. They need to renew their request to have Easter brought in. They need to get some case law, some federal case law, U.S. constitutional case law. Yeah, I hope all those that are involved in the corruption up there, I hope the FBI is going after them. So, PG, I do think that the judge is going to have to allow ARCCA. I think this whole thing, like I said, they struck out. So she didn't want to make a ruling because it's too late in the day. And she's probably going to make the defense wait on this thing. I mean, why doesn't she just come out with a ruling right away before she leaves the bench? She could do a verbal order and ruling and then follow it up with a written one. Are they going to be held wondering for several days? Why doesn't she just announce it tomorrow morning before they start with the first witness, who, as I understand, it's going to be Jen McCabe? So, wow, well, that'll be something, won't it? Altair Hutchinson, is there a legal way if the judge can be reprimanded? I don't know how their process works up there. I mean, there can be complaints made against judges for not following the judicial code, but in this particular case, I don't know that everybody's all in the same with the same party up there, so you really don't have a chance of anything happening to real people in there out of control. Yes, Eliza Krogan. Unless he seems more aggressive, he's talking louder. He's not passive. He's talking quicker also, but he's very, very good paced. Very easy to understand him, and he has that kind of credibility and conviction in his voice that I've talked about before. That the jury really can relate to Alessi. I hope he does the closing. PJ, you're saying Richard Green is a true expert in Cellbrite. Jen Googled how long to die in the cold at 2:27 a.m. 2:27 a.m. and deleted it. Yeah, I believe that too. This Cellbrite guy, I just don't trust. Yeah, it's unbelievable the way this Dr. Wolf is treated. And Rentschler as well, Dr. Rentschler. It's just unreal. But you all saw it, and it's going to be out there on the internet for a long time. Ms. Holmes, you're saying Judge has to talk to Morrissey, the DA, before she makes very important decisions. She's I don't know if she's doing that, but if she is, it's flat out wrong, improper. Judges should not be talking to another side ex parte. That's unethical. Jen McCabe tomorrow, she's going to be having some serious issues to be dealt with. Yes, KCL Whiffen still needs to be cross-examined. I mean, this whole thing is going all out of order. I mean, it's just so dysfunctional, and I think that can help to the defense, because this trial is so disjointed. It's like a yo-yo effect. Don't know if Whiffen's back on tomorrow, but I heard Jen McCabe was. So Lewis Bull, you're saying it's going to happen. They're all coming down one by one. It needs to happen. I always call the jury the equalizer when I'm dealing with corruption on the other side. And unless the judge here, she's able to pick the foreperson, and she was able to help do a lot of the steering of who gets makes it on the jury and who gets booted off. The defense needs to make sure that they see all the numbers that are in this raffle wheel, and if they have too many of the same numbers in there, that means that you could rig the system that way, because you could have it where folks that you think are not buying into the prosecution's case, you could put their numbers in there more than any other, and have a good chance of getting them booted off as alternates that don't make the final 12. So if I was defense, I'd be wanting to verify all that beforehand. Yeah, unless he's genuine, definitely. I think he's the most likable of all their attorneys, and he's super competent. I mean, he's just super brilliant guy. I think he's the smartest, and he's the most likable and relatable for the jury. So automatically, I think he would be the guy to do the closing. Lisa Co, you're saying the jury answered Yannetti back, "You're welcome," as the whole before they left for the viewing. They had no response for Hank. That's an interesting take. It's a good sign. Kiki St. John, you're saying that Hank is discussing here about the fifth attorney, said that would not be tolerated in any courtroom in the U.S. Bias judge, of course. Keep praying for justice. These evildoers is going to come crashing on their heads. Val Wolf, my question to you is, what, if anything, do you think the Commonwealth will act now that they know for sure the feds are indeed watching? I don't know that these guys are going to change their behavior. I think they're too much wrapped in this mindset. We got to destroy Karen Reed and the defense team. Lizette, you're saying when Brendan is by Dr. I think you mean Renser with an R. Judge and Brendan make eye contact. Brendan shakes his head like he's saying no. Judge looks away, puts her glass on, and begins to write something. Why this signaling? She's there to help the prosecution, not administer a fair court of justice. KFG, you watched Microdot's clip today, featured the judge's hands shaking, and MD suggested anger. I see fear contrasted with Brendan's bizarre confidence. Now I question if she's been threatened. No, I don't think she's been threatened at all. I don't think Brendan has confidence so much as I think he's worried because he's got ARCCA to deal with. So he's projecting confidence, but when you're this aggressive and off the rails and being such a jerk to the ARCCA experts, you're worried about your case. You're not sleeping easy at night. Marcia Braga, can Jen plead the fifth? She could plead the fifth. If she's got grounds to, that would be interesting. Okay, Albert, motives can occur with a matter of seconds. You must be thinking like the judge that somebody only has a motive to hurt you if it's a long-standing grievance. And I saw there was a comment. I can't remember if it was on YouTube or if somebody sent me an email to that effect. I think it was a YouTube comment yesterday, last night, or maybe it was, I think it was probably yesterday. And talked about how John O'Keefe had gone to the Canton Police Department to report there's drug activity in his neighborhood, on his block and whatnot. And the person he reported to at the police station was that Chris Albert, and Chris Albert's son is Colin. And so supposedly there's a theory that Colin was the one that was involved in that. So that's what somebody had for a comment. So could something like that be in theory possible? If that was true, then that is a legitimate angle of attack. I just had never heard that before. Yes, thank you, J.R. Cuber. I would say that I think the ARCA folks have to be allowed in. I don't think the judge. I think the judge realized she's got no grounds. Hank wasn't able to find any gotcha moments on these two experts. By the way, as I said last night, don't don't give me any super chat money. Just help fund the defense team for Karen Reed. Thanks, Lisa. Yeah, just keep your money though. Wouldn't a hit and run show a sudden phone movement? You would think so. I just think whatever could look bad for Karen today from this Ian Whiffen guy, I think he's going to be exposed through the defense. I just don't trust what he says. Russian Aloha, you're saying it's so sad there's no justice for John. He's completely lost in this mess. Hank is not on the side of truth and justice. It breaks your heart. Yeah, it's very sad to see that, isn't it? Yeah, the judge doesn't have confidence. That's why there's a buffer zone. I mean, that's a massive buffer zone. It's totally unconstitutional. The federal judge failed to do his duty and declared unconstitutional and make it much more restrictive. Brandon Bernhardt, you're saying I was not expecting Carl to be in favor of the defense on this case. I was going to have to go back and listen and see how he's come to this conclusion. Well, just look at ARCA witnesses. Look at how the dirty and underhanded the prosecution is acting. They don't act that way, Brandon, unless they know they don't have a case. All right. I think ARCA's in, Brit Chick. Just like my title says, before I even knew that they were going to come out of this as awesome as they did, I just knew that Brennan wouldn't be able to shake them. It was just all just a big smoke and mirrors, false accusation by Brennan against the defense. See, Shay, you're saying case is crumbling. Witnesses all been terrible for the Commonwealth. Truth seeker behind the facade of every bully is really a big coward. That is absolutely true. Liz Pongratz, Brendan is scared he's supposed to be the Commonwealth's salvation and found out he's in over his head. Even his trial doesn't fall apart, his appeal will bury his future. Judge Bevis, too. Yeah, why would you want to sign up to this? You're going to be linked to this the rest of your life? I can't believe that. All right, it's 11:17. It's over 2 hours now. Let's go to one more question. I'll call it a night or morning, wherever you're at. Straight out of Canton. Colin didn't live in his block anymore. Well, that doesn't mean that he couldn't be working there, still doing stuff there. So who knows? I don't know why the defense hasn't used that theory if it's a legit theory. Yeah, so donate to the Karen Reed's Defense Fund. The more outrage you have, just use that to motivate yourself to give money, okay? Do not send me money. Do not send us money. We don't need your money. Give it to the Karen Reed team. Okay, yes, they're acting like they're protecting somebody of large value here. Yeah, I'm sorry if I got too angry tonight, if I was too loud, but man, this is not easy to take. Not easy to take at all, seeing this disgrace of a system up there. Rosemary Gallagher, Dr. Wolf, his wife, and 4 children threatened many times the past 2 months. Pretty sad. I just got to say, for Dr. Wolf to be able to go through this, and also Dr. Rentschler, for them to go through this harassment, haranguing, and abuse. This is an abuse of process. This is an abuse of law done by a judge and a prosecutor. For them to have to go through this, and their family's being harassed, and he's having to jump through hoops. He started to talk about how he's missing on his 10th anniversary with his wife. And then, of course, Brennan objects, and the judge sustains it. So they've gone through a lot, and the judge and prosecutor trying to put them through the ringer and disgrace their honorable names. So shame on the government, shame on the prosecution and the judge for this. All right, Albert, goodbye. You're nothing but a troll. He's forever banished. So I saw somebody alerting me to that. So good riddance. Go join some of the few rabid anti-Karen Reed type channels. There's not many of them, I don't think. All right. Well, thanks, Paige. I'm in good company. All right, I'm going to go ahead and sign off. Thanks for your support of the justice cause. And like I say, it's going to get really, really unreal here in the coming days with what's going on in this court. So more to follow. I'll hopefully be able to join you tomorrow night for a recap of tomorrow's court session. So take care. Hope to see you then. Good night.